The Zoom, correct?
Yes, sir.
Okay, so we'll shut that down. Okay. Close the state.
And Your Honor, from the evidence brought out, and the fact that the court is allowed to consider affidavits, sworn statements, the state would have an official statement from Douglas Hutchenson regarding the incident that the defense brought out. And they also have a sworn statement from a John Michael Gustafson regarding Ms. Cole's domestic violence arrest. I'm sure y'all are objecting to these going to court.
Is that the same day?
Same one.
Is this one?
Same.
We got the whole thing. If you want to put this whole one in. If that's the same one.
I was just doing the affidavit because that's the, but I have no objection to putting the whole thing in.
Your Honor, it's my understanding the state's going to place. And I
Are you
don't
putting the whole
have
one? Sorry, if I'm confused. I just want to make sure we're doing the right thing. Do you want to put the whole thing into evidence?
Absolutely.
Okay.
Let's put it right.
Your Honor, it's entitled Record of First Appearance of Non-Adversary Probable Cause of Determination, which we just shown the state with respect to the battery.
So that's the report, the 77 page or whatever report that was.
This is not a 77 page.
Well, but is that,
In any event, it has to do with a domestic violence charge involving.
okay, so that's an earlier report.
It is, Judge, and the state had alluded to it, to putting a portion in. We're moving the entire file in without objections, ma'am.
Without objection.
Call it D1, call that market.
You want to call it defense 1 or defense A? Defense A.
Defense A, man, Judge.
You may. Is that the only exhibit for the defense? I know the state has a couple there.
And the state has a Niceville Police Department arrest report for Susan Rebecca Akers, which is her maiden name, for a 2/9/2011 arrest. It's a sworn statement from John Michael Gustafson.
It's just one document
Just one document.
without objection, and that would be State's Exhibit, what's the
Where's the other one? And then,
15? 13?
no, I think it's 16. It states 16.
State's Exhibit 60.
And the state also
And that's
has
without objection from the...
It is, Your Honor.
Thank you.
a sworn affidavit from Angela Tate, the Niceville Police Department, for Susan Akers for making a false report of domestic violence.
Yes. Judge, there's no objection to this being admitted.
Very good. That would be State's Exhibit 17.
Yes, sir. May I approach?
You may. Did you already hand in 16? This 17, this is 16. Thank you. Is that all from the state?
That's all from the state, Your Honor.
Very good. When the state's ready, they may make a closing.
Your Honor, a gun is a gun is a gun, and a lie is a lie is a lie. There's been a lot of testimony brought out today, and there's been a lot about the text messages. And the first thing that the state wants to do is go over some of those text messages because they haven't really been brought out in their completion. On November 5th,
There are several stacks of text messages. What number are you?
we are alluding to State's Exhibit 15.
Go ahead.
And we're going to start on page 15. Susan Hutchenson to Doug Hutchenson. Feeling lonely, but that's more often than not. Susan Hutchenson to Doug Hutchenson. Enjoy your evening. Doug Hutchenson to Susan Hutchenson. For your information, I'm lonely too. I love you and miss you. Susan Hutchenson to Doug Hutchenson. You aren't ready to commit, right? Doug Hutchenson to Susan Hutchenson. That is a very open-ended question. I feel that I am committed to you. So what do you mean by commit? Susan Hutchenson to Doug Hutchenson. A bit earlier, you said committed was for marriage. She messages again. You said you were waiting for the right time, trust, etc. She says, so if you decide to trust me, let me know. Then she says, it's Saturday evening, you aren't pressed for work, so ... He says, Doug Hutchenson to Susan Hutchenson, what do you mean by so? Susan Hutchenson to Doug Hutchenson, do you want us to have a fully committed relationship or not? That conversation continues. She says, after he responds, I'm not complaining, but I'm a little confused. She says, I asked you to come stay with me, and you said you didn't want to catch anything I had, which is totally understandable, but don't blame that on me. Then this is where, Your Honor, she starts picking a fight. You toy with me, just keep me at a safe distance for you. Screw that, leave me be. And she does say, leave me alone, goodbye, leave me alone, goodbye. And at some point, he does come over. I will just wait on your front porch until you come see me. I just want to make sure you're okay. She says, I am fine. I'm tired of you toying with me. We're done. Yep, I said it, done. He said, I'm sitting on your front porch. She does tell him, get off my property. He says, if I weren't in love with you, I wouldn't even be here. And this does go back and forth, leave me alone. But he says, okay, I'll sit across the street and no empty parking place. And then he tells her, and this is a really important message, Your Honor, that the defense left out in their questioning. I guess you're right. This isn't about me or what I want. This is about you and what you want. I love you. If you change your mind, then you need to contact me and let me know. At this point, I'm assuming that you meant it when you said you're going to start dating people. That's a game breaker for me. Whatever you decide, I hope you're happy with the results. I mean that sincerely. There's no cursing, there's no fighting, there's nothing on Mr. Hutchenson's part. Her response to that message is, fuck you. She says, I want no one. You are just looking for an excuse to not feel guilty about your actions. This is in the same evening that she asks him, are you ready to commit? He says, I'm looking for a way to work out a future and permanent life with you. She says, right. Now this is an important message that the defense also left out. I'm not going to sit outside of your house and be arrested. I came back because you called me and said, do I want to talk? I'm headed home. You called me and said, do I want to talk? Her response to that is bullshit. His last messages are, won't you tell me what you want me to do? Can you tell me what you want me to do? I guess not. Good night. And that's the last text message we ever see from Doug Hutchenson. Those text messages are not consistent in any way, shape, or form with her story. That he showed up on her doorstep, someone who was very familiar with guns, holding a rusted out .22 by the barrel, and came into her home demanding that they be together. That is the exact opposite of what those text messages say. She is pressuring him for a committed relationship. And he says, yeah, I want to be with you. But it's not anything like she tells Investigator Mayweather. She also says, I don't have a gun. I don't own any guns. Connie Jinks said, yeah, she had a gun. A gun to scare away bears. That's what she had it for. And John Jackson says, have you named your gun yet? 3 days beforehand. She had a gun, and she lied to law enforcement about it. Pure and simple. That's facts. Whether or not that gun is a .22 or a .45 or a shotgun, it doesn't matter. A gun is a lethal weapon, period. When you shoot a firearm at somebody, you can kill somebody, period. Now, getting to the evidence, Your Honor, walking into the house, you see Mr. Hutchenson lying on the floor in a pool of blood with his pants down around his ankles. He was unarmed, fell right outside of the bathroom. The scene, Your Honor. If you look at State's Exhibit 4, there's not a speck of blood on that door. Not one, not a little bit. Not even a little tiny bit. Miss Cole said he was lunging at her from the toilet, and she shot at him. There's no blood there. And that open door. Where is the blood? To the right of the toilet. If Your Honor looks at State's Exhibit 5, on that shower curtain to the right. That's where there's blood. If Your Honor looks at State's Exhibit 6, there's blood all on the wall leading out of the bathroom. You heard Dr. Oleski testify that that was a downward trajectory, that shot in the cheek. It's consistent with sitting down. It's consistent with being on the toilet. An unarmed man sitting on the toilet. What is consistent about her story is that she came up to him with a gun. She did. And fired on him while he was sitting on the toilet. And that's first-degree premeditated murder. But she doesn't just fire once. She fires again. As Mr. Hutchenson gets up in some form or fashion or leans over to the side in some form or fashion, more likely by the scene, Your Honor, he leaned over towards the shower curtain and the tub because that's where the blood is. And then he tried to get up with his pants down around his ankles, or while he's leaning over, Miss Cole shoots him again in the back of the neck. It's such a severe downward trajectory, it ends up in his lungs. And these are not close wounds, Your Honor, of somebody lunging at somebody, where they'd even be remotely in the distance of being hurt by an unarmed man sitting on the toilet with his pants down. There's no soot, there's no stipple. These are not close. These are far away. Mid-range. Defense brought that up. Mid-range. Away. Mr. Hutchenson falls right outside the bathroom. Right outside the bathroom. And perishes in a pool of his own blood. Miss Cole puts the gun on the table, as Your Honor can see in State's Exhibit 2. This rusted out .22. But the gunshots were heard 20 to 30 minutes before she called 911. Before she called 911. And there's two sets of gunshots heard that evening. One person heard them around 6 o'clock. They heard gunshots. Practice shots. And then a neighbor heard the actual gunshots later. There are 5 empty shell casings in that revolver. 3 practice shots and 2 shots that killed Doug Hutchenson. If Your Honor looks at Exhibit 7, you can see the schematic for a gun in the back, but she didn't know anything about guns. She didn't own a gun. She had an open drawer with an empty spot and a schematic for a weapon. Your Honor, the state has presented proof evident and presumption great that Susan Cole committed the offense of premeditated murder as charged. This means that the court can hold Ms. Cole without bond, without any other reason. There is no doubt that she shot Doug Hutchenson. She admitted to it. But then she lied about the circumstances because that's what the physical evidence tells us. It's not a matter of whether you believe he lunged at her or not. The physical evidence says he was sitting on the toilet when that first shot came down. She claimed to not own a gun, not know much about guns. We know all that to be untrue. The text messages tell us so. Her friend of 40 years, 40, said she had it out for Doug Hutchenson. We know from the text messages that Mr. Hutchenson came over because she called him to talk. She wanted to be in a committed relationship. She asked him. It was not the other way around. But one of the biggest things is if someone is a gun enthusiast or familiar with guns, and they have a perfectly good semi-automatic weapon in their car, why on earth would they come in holding a rusted out .22 by the barrel? They wouldn't. That's simply made up by Miss Cole. And we also know that that gun was given to her to scare away bears from earlier. If things happen the way she said they happened, there wouldn't be that blood on the shower curtain. He wouldn't be falling right outside the door. The scene would just not be the way it is. And we know she lies. She waited to call 911, according to the neighbor. A gun is a gun is a gun. It doesn't matter what it's for. It's lethal. And a lie is a lie is a lie. And the state has given you proof evident, presumption great, that Ms. Cole is constitutionally not entitled to pretrial release. Doug Hutchenson was killed with his pants down sitting on the toilet, Your Honor, by someone who made a conscious decision to get a firearm, walk up to him, and shoot him twice. That is first-degree premeditated murder. And the evidence, the physical evidence the state has given you today is proof evident, presumption great, that she committed this offense, and she should be held without bond.
Does the defense wish to make any closing remarks?
May, Your Honor. May it please the court, counsel. Your Honor, what I'd like to do is review what the state's witnesses agree to be undisputed. And the state, candidly, will agree that on November 5th, Mr. Hutchenson went to Susan Cole's home, not his home, and entered the home after she had told him and texted him, "Get the hell out of here, get off of my property." The state knows this. They presented the witness who told you this, Your Honor. Mr. Hutchenson was shot by Ms. Cole while in her home, and he was shot by a gun that he brought there. Your Honor, any sensible view of the evidence would lead to the conclusion, Judge, it's a .22. She didn't have any .22 ammunition. The ammunition was in the owner's trunk. It was Mr. Hutchenson's gun. That's why the ammunition was in the trunk when law enforcement searched his trunk. State forgot to ask that question, but Mr. Shaw didn't. One wonders why that is the case. Judge, everything we've heard here today is exactly what we knew on November 6th, when Ms. Cole was originally arrested and charged with second-degree murder. And in second-degree murder, Your Honor, as this court is well aware, she's facing a possible sanction of life in prison. Based on that, the court correctly ruled and entered an order that she should be placed on bond, and she was, with pretrial services supervision. Here's what could not be clear. During the 9 months since then, she's done exactly what she's supposed to do. There have been no violations. If there were violations, the case officer would have known about them. The reason he doesn't know about them is none are in place. Your Honor, we could argue, of course, that Ms. Cole did leave Okaloosa County on one occasion since November 5th. She went to a church camp or a conference in Florence, Alabama, with the permission of her pretrial officer. Your Honor, she does not present a flight risk Your Honor, the case she's facing is based on the exact evidence that the state has known has existed since November 6th. Now, she had to sell her home. We heard about this on Saturday when the state on Friday obtained, and Judge, we know what political pressure is. We know what familiar pressure is. We're looking right at it right now. Everybody knows it in this room. She's facing the same sanction the state has known since November 6th. She's facing life in prison. And yet last week, for the first time, the state believes that she should not be out at all, that she presents, one, a flight risk. The evidence could not be clear that she's not a flight risk. She hasn't gone anywhere. Or that she's a danger to the community. I believe that's the term the court, well, this court wants to look at that. There's no evidence whatever that she's a danger to the community. She has not violated any rules at all while out on release. Now, the state suggests, the evidence is very clear, he was shot on the toilet, and we have to believe that unless we believe the state's witness, who agreed with me that the trajectory of the projectile is entirely consistent with the shooter being lunged at by Mr. Hutchenson. This court will recall her very clear testimony. The state forgot to tell you that in their argument. I think it was probably an oversight, but that's what their witness just told this court. With respect to the time for the 911 call, the state put on 3 different witnesses. The first, 2 hours before, target practice. My guess is Ms. Sandler thought of that after we started this hearing today. Target practice. How could she take target practice with a gun that Mr. Hutchinson brought later when he was told, don't come to this house, but he did anyway? Now, I'm well aware this is not the trial. I'm also well aware that Ms. Cole is presumed to be innocent and is innocent and is clothed with that presumption until and unless a jury finds that the state has removed all in any reasonable doubt. But what we're left today with is this court's consideration is, did the court in November rule correctly when, based on all the information we have right now, when he set a bond for her that she's complied with, well, until last Friday when the state, based on things I just related to this court, sought and got an indictment. But the facts are the same. We've known them and the state's known them since November. Here's how concerned the state is with respect to the safety of the community and the need for Ms. Cole to be incarcerated without any bond, whatever. My guess is it's most important from the standpoint of severity case the state has. So important that the case officer that they brought today by Zoom without his report in Tennessee is brought to this court for this court to make this important consideration. How important is that? How hard is it to get someone on a plane? He's in Tennessee. Or a drive down here, if it's that important, if they were that afraid and they were that concerned that pretrial detention was the appropriate thing to do, he'd been sitting right over there testifying for me.
Your Honor, I'm going to object at this point. This is improper argument.
Stay on point, counsel.
But the evidence he did provide that we could hear was as follows. Quote, is everything in your report true? Yes. Did Ms. Cole cooperate fully? Yes. Was there anything there that contradicted that which she said during that evening when she talked to Investigator Naylor? Well, no. Is it consistent with a reasonable defense to the case? Of course it is. But it's also consistent with the fact that in November, when the court ruled correctly and she was placed on pretrial release, the best indicator of the future is the past in many instances. In this case, since November, while posting her bond, she's done exactly what she should do. She hasn't done anything that she is not supposed to do. And it's overwhelmingly clear that the state hasn't met. It's overwhelmingly clear she should be released on the same bond she was out on. To suggest otherwise is inconsistent with the state's witnesses and the evidence before this court. We respectfully suggest that not only is the state's motion for pretrial detention properly and yet respectfully denied, but this Ms. Cole be released under the same terms that she's been living under successfully since last November. Thank you, Your Honor.
Your Honor,
Yes.
the state did not address bond because the state was addressing the Arthur hearing. If I may address the conditions of bond, or is that necessary?
Court finds that the state has met its burden with regards to the proof of guilt as evident or the presumption greater. The defense, the burden shifts to the defense, to which arguments have already been made. The reason why I don't want you to immediately talk, I want to give you an opportunity to make sure, because this is more or less bifurcated.
Yes, sir.
Or a two-step. I just want to make sure before the state offers its arguments, opposed to whether there are reasonable conditions of release, whether you wanted to add anything more before I allowed the state to respond. I know you answered a lot of them in your remarks, but I just wanted to make sure you didn't have anything else.
Is there in the event I have an opportunity to perhaps respond to the state's position, I'm fine with that if that's fine with the court.
I think the defense has the burden, and you're welcome to add any additional things, then I'm going to give the state the opportunity to reply.
And I appreciate that, Your Honor, and I understand that it's a bifurcated, if you will, consideration that the court is making, and I have understood in respect to the court's ruling with as you have stated, that the state has met its burden. What I might suggest, Your Honor, is the court consider that which she has done since she was out on bond since November and reiterate all the things she's done correctly. And that is done everything she's supposed to do, be in touch. And I put it in my bond motion, Judge, and not to be redundant. She's had to sell her home, and she's had to, well, frankly, it's hard to get a job. She has a part-time job. One can understand the difficulty. But she resides in Okaloosa County, has not broken any law, has not violated anything that she's been asked to do. We've been retained to vigorously defend this matter. She's retained us, and quite frankly, she is of limited financial means and has taken that which she has for us to do our best to represent her interests. Judge, we would suggest, respectfully, that the order that was in place that she was adhering to, and there's no reason to suggest that she would do any different, because the penalties she faces, Judge, are the same ones that she was facing in November. Those would be my remarks. Your Honor, thank you.
Your Honor, the defense has presented argument but no evidence that Ms. Cole should be granted pretrial release since the state has met their burden. Ms. Cole did sell her home for $325,000 in cash. The state has not found a lien to be satisfied on public record. Now, I'm assuming that she has paid Mr. Flowers and Mr. Shaw, and I have been told by counsel, to be honest, that she has paid an expert. I don't know how much. I don't know the exact details, but I know that that creates a significant flight risk to have access to that much cash. Because as of Friday, because the state did indict, we didn't receive and you can read from the evidence that's been presented, we didn't receive that report from Dr. Oleski for several months. A first-degree murder indictment is a game changer. It's a mandatory life sentence, and it automatically creates some risk of flight. She has access to cash. There's been no evidence presented that she's working. There's been no evidence presented that she has ties to the community. There's been no evidence presented that she's going to stick around and show up to court. None. And that's the defense's burden. The state has met their burden, and we are respectfully asking that Ms. Cole be held without bond pending her trial.
Judge, with respect to the violations, the court can review the record. There are no the court record, then that would be the case. Judge, I think that you're apprised of the situation in total.
I don't think they're disagreeing that there's been any violation. I think that was argued.
That was not argued, Your Honor.
So I think everybody is aware, and defense counsel would even agree begrudgingly that things come out during the course of an investigation that are different from the original charging documents. It's common that charges are changed and upgraded over the course. As a matter of fact, it's extremely common. And so to say that the circumstances are the same as when the original bond was issued, I think the court would respectfully disagree. The one thing that the court made note of, it's interesting, is in the state, in the seminal case, the Florida Supreme Court case, 40 some odd years ago, State v. Arthur, that they specifically cite to certain historical issues relating to not allowing any bond. And that issue, the single issue they raise, is flight risk. That is a comment to the point where in many circumstances it's like automatic. It's a life sentence. It's an automatic flight risk. They implied that. But certainly it raises the spectrum. The state has raised that. And the issue of available money does come into play. So I think that the defense has not overcome a well-founded belief of the need for a no bond at this point, because the court finds that there are no conditions of release that could ensure the accused presence at trial at this point. So the court's ordering the bond be revoked, and no bond be issued at this point. Thank you very much. If you'll provide me an order.
All right.